Hello, Joe Zarzaur here with Dr. Evan Malone. It has come to my attention over the last several months that we get a ton of calls with people having COVID-19 medical malpractice questions. And I thought it would be worth shooting a video to talk about the issues involved in those situations. First of all, everybody remembers that we went through a pandemic. And everybody remembers that the healthcare practitioners were the one profession that was on the front line during all this. Yep. And when all that was going down, there was a public movement or outcry to protect them. I always felt it wasn't necessary because they were viewed as heroes anyway, and you can't convince a jury to find against a hero. So good luck trying a case against them to start with. But for whatever reason, because the legislature is the legislature and they decide they want to do something politically, they think politically advantageous for them. So they champion a statute that officially protects healthcare workers who commit malpractice in a COVID-19 situation. Now, ordinarily, as you know, we handle medical malpractice cases. They're complicated enough, right? They're very difficult. There's all kinds of tort reform that's already passed in Florida that restricts who can bring a case and how you have to bring it. So there's already a lot of safeguards with medical malpractice cases. So many safeguards that to bring a medical malpractice case in Florida and to bring it correctly, you're going to spend between $100,000 and $200,000 just to get the case to court. That in and of itself is enough of an incentive to only bring those cases that have merit if you're going to spend $250,000 on it. So, but the legislature in their infinite wisdom decided to pass a statute. It's behind us. We're also going to put a link to it. But it was Senate Bill number 72. And basically, I'm summarizing 12 pages of fine print. But basically, if you bring a case for medical malpractice and it relates directly to COVID-19, sickness, treatment, anything directly related to your diagnosis, failure to diagnose COVID-19, anything with the word COVID-19 in it directly, you're pretty much prohibited from bringing that case. You have to jump through 1,000 hoops, basically, that make it practically impossible to bring a COVID-19 based case.
And the statute is 1 year.
And the statute of limitations is 1 year instead of 2. So it is a very, very, very complex set of laws or procedures rather that adds to an already complex medical malpractice procedure. The part that I wanted to speak to is another part of the statute that deals not with COVID-19 cases directly, but we've all heard about the situations where somebody is neglected either because of the COVID-19 pandemic or because they were hospitalized during all of that time. And so the statute addresses COVID-19 related claims, not just COVID-19 cases, but COVID-19 related claims. And basically what it says is if the hospital or provider can prove a direct relationship between the COVID-19 pandemic as a whole and whatever they did to this patient that doesn't relate to COVID-19, for instance, staffing, resources, if they can draw a straight line and say it's directly the staffing issue that ended up killing a patient that didn't have COVID-19 at all, had a heart attack or something else, if they can draw a straight line and say it was a direct cause, the inattention to that patient was directly linked to the COVID-19 pandemic, then they also could possibly come up under the statute and be protected.
Yeah, it could be plenty of attention, but I guess the thing that comes to my mind is acute appendicitis, very treatable. You go to the
not a COVID-19.
Yeah, you go to the ER with that. COVID is nowhere on your chart or any concern at all. You would normally go right to the operating room and have your appendix taken out. If the explanation as to why you didn't go to the operating room is they didn't have one available, they didn't have a surgeon available, the whole staff was sick, and you die, that's going to be the direct link that they tried to tie to COVID.
Yeah, and the medical records obviously would be the best evidence of that. So obviously if they have in the medical records, well, we try to get this person into the surgery suite, but all the surgeons that were on call had COVID-19, or all the surgeons that were on call were attending to patients in the ICU because of COVID-19. That is the direct cause that could link an appendicitis case and give that appendicitis case protection from medical malpractice lawsuits, even though it's not a COVID-19 case directly. So the statute goes beyond just the COVID-19 affected patients, but it reaches out and grabs and protects doctors from COVID-19 related cases if they can prove a direct connection to the malfeasance or misfeasance and the COVID-19 pandemic, which I thought, it surprised me when I saw the wording of it. But I guess the direct cause is the way that you would get around that if you had a regular malpractice case. It's a very complex area of the law. It's even got more complex with this statute. I would encourage anybody that has a potential COVID-19 related claim or a COVID-19 claim to reach out to an expert who's board certified like myself, so we can do the analysis not only under this new statute, but under the ordinary medical malpractice statutes, because they all apply to this. And we can give you an opinion as to whether or not there is a case. If you have questions about a medical malpractice matter, even if it's not COVID related or even a COVID-19 direct cause relationship type case, but it's just a straight up appendicitis case that happened after the pandemic or before the pandemic, you can find us on the web at zarzaurlaw.com, or you can call us at 855-HIRE-JOE. Thank you.